Hello, this is Matt on the Moon Lambeau channel. A judge has outright rejected Judge Annalisa Torres's ruling, her decision in the SEC v. Ripple case. Specifically, the most important part, the part where she declared that XRP is not a security, and she did so by noting that XRP is not an asset that embodies any sort of requirements of Howey. That's closer to how she worded it. But that, of course, means that XRP, by the nature of existing, is not a security. That specific part, that most crucial part to the SEC v. Ripple case, was rejected by another judge, and that judge is in the same district as Judge Torres, which is interesting here. So it's hard for me to wrap my brain around how a judge could actually side with the SEC in terms of thinking that an asset itself, by the nature of it existing, could be a security. It's absolutely baffling, especially when you think out to what Attorney Lewis Cohen put together. He's the author, along with help from a couple others, I believe, of the Ineluctable Modality of Securities Laws, where he went through every single case dating back to 1946, showing that there's never been an instance where there was some sort of violation if there, first of all, wasn't a contract, and then also he found that there's literally no ruling where the asset itself, the underlying asset at the core of any case, was the actual security. It's never happened. And so to have a judge rule to the contrary is absolutely mind-blowing. Now, the good news is that it doesn't matter what the hell this judge says, because what Judge Torres said right now, that's the law. That's why all of these exchanges in the United States have already relisted XRP. Most of them did the same day the ruling came out, in a matter of hours, in fact. It was really impressive. I wasn't expecting it to happen that quickly. That was a very pleasant surprise. But this judge's ruling in a separate case is not going to have an impact on whether or not XRP is or is not a security. So that's the good news. But it's still ridiculous, and I'm going to share with you what Attorney Jeremy Hogan as well as Attorney John Deaton had to say to this point. And I think that Attorney Deaton, based on what he said, it seems like he's going to be unpacking more in the future. But I'm going to share with you the latest from him on this. But I'll just tell you at the outset, his perspective is pretty much like mine. Like, in the end, although this is completely ridiculous, that's how I'd word it anyway, this isn't going to impact anything. Look, XRP is as good as gold. Because even if there's an appeal, I've already articulated why in recent videos, so I don't want to rehash that again, but even if there's a successful appeal, there are other reasons that Judge Torres can come to the conclusion that XRP isn't still a security by factoring in the other Howey factors, which she didn't have to do. And the reason she didn't have to factor in all the Howey factors in the summary judgment decision is because if there's one prong that isn't met, then it's already not a security. The transaction, not a security. And she found that one of them doesn't. So she has to go back. And so I'm not particularly worried about it. Even if it magically somehow got to a higher court, say it got to the Supreme Court, I still don't care. It's not going to matter. The SEC's on the wrong side of history. So anyway, before breaking this down further and sharing with you the ridiculous specifics here, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So here's a headline from CoinDesk. Everybody's talking about this today. Judge rejects Ripple ruling precedent in denying Terraform Labs' motion to dismiss SEC lawsuit. And so they're talking about, this is the whole, you guys remember, obviously, the Terra Luna collapse, which is what set the crypto asset class into a spiral last year in May. And having to do with the founder, Do Kwon, that's the guy that's on your screen right here. That's this particular lawsuit. Piece reads as follows. A federal judge denied stablecoin issuer Terraform Labs' motion to dismiss a lawsuit from the U.S. Securities and Exchange Commission on Monday, saying the regulatory agency has sufficiently argued it has jurisdiction and asserted a plausible claim that Terra USD, or UST for short, that's the ticker symbol, UST, the Anchor Protocol in Luna, may have violated securities law. More importantly, perhaps, Judge Jed Rakoff of the U.S. District Court for the Southern District of New York also rejected the use of a ruling from fellow Judge Annalisa Torres, who recently ruled that Ripple Labs, another defendant against the SEC, did not violate securities law in making XRP available on secondary platforms for retail investors to purchase. The SEC sued Terraform and founder Do Kwon earlier this year on charges of misleading investors about UST, a stablecoin pegged to the US dollar through the Luna token, and fraud. In a motion to dismiss, Terraform argued that people bought UST for practical purposes and did not have an expectation of it being an investment. Earlier this year, attorneys for Terraform also pointed to the recent Ripple ruling, in which Judge Torres said that while Ripple had violated securities laws in selling XRP to institutional investors, retail investors could not have known they were purchasing XRP from Ripple because they bought the token or intermediary exchanges through Ripple's programmatic sales. Excuse me. And that's worded incorrectly. It wasn't through Ripple's programmatic sales. Ripple engaged in programmatic sales separate from what was occurring on secondary markets. So it could be to an exchange, it could be to whatever entity, and then that could ultimately end up on an exchange where people could purchase it on secondary markets. But Ripple doesn't control that. Once it's out of Ripple's hands, they don't control that. And you and I have never purchased XRP from Ripple because they've never sold to the general public. So that is worded incorrectly, but the sentiment, I think they were mostly getting right. Anyway, piece continues. In his order Monday, Judge Rakoff said he rejected that approach. Check out this quote. This is absolutely Looney Tunes land. I am so glad we had Judge Torres in this case, because things could have gone way off the rails. Things could have gone drastically, negatively differently, and we all could have been screwed. But check out this quote from the judge. Whatever expectation of profit they had could not, according to that court, be ascribed to defendants' efforts, he wrote. And then here's the rest of the quote. But Howey makes no such distinction between purchasers. And it makes good sense that it did not. That a purchaser bought the coins directly from defendants or, instead, in a secondary resale transaction has no impact on whether a reasonable individual would objectively view the defendant's actions and statements as evincing a promise of profits based on their efforts, end quote. So, okay, that's Looney Tunes. That is wacky. Because it's not even so, I wouldn't focus on when she was citing institutional and programmatic sales, which is the language that the SEC used. That's why she even used that language. But what she did was she applied the Howey test to those types of purchases, which is, of course, the correct approach. And so this idea that XRP itself could be a security, it's completely nonsensical. So it's just like when the orange grows, with the orange groves and oranges back in the Howey case in 1946. It would be, if the judge, if this is what he really thinks about the situation with XRP and the SEC v. Ripple case, then if he were making the decision in the 1946 case, if he were a Supreme Court justice, then he would have to argue, if he's going to be intellectually consistent here, if he's going to be logically consistent, he would have to argue that it doesn't matter if you buy the oranges directly from W.J. Howey Co. or if you buy oranges in a grocery store. Anybody, with half a brain would understand that we were counting on the efforts of W.J. Howey Co., even if you buy the oranges in a secondary market like a grocery store. You see how stupid that is? It's not the asset itself that is the security. It has never been. It's astonishing to me that somebody with this level of power and decision-making ability, impacting people's lives, could have such an egregious take on the law. It's flat out incorrect. It's disgusting. Anyway, piece continues. The SEC has already hinted that it may appeal the ruling. During the motion to dismiss stage, the facts in the SEC's complaint must be assumed to be true, he noted, and the SEC said in its filing that Terraform had embarked on a public campaign to encourage both retail and institutional investors to buy UST. Yeah, well, what happened with Ripple, though, in the SEC v. Ripple case? John Deaton has sworn affidavits, proof from thousands of XRP holders, that proves that the majority of first-time holders of XRP, first-time purchasers of XRP, didn't even know Ripple existed. And so when the judge says here that, how did he word it here? In a secondary resale, he wrote, said, transaction has no impact on whether a reasonable individual would objectively view the defendant's actions as statements. And so there you go. Even if you don't know about it, you're not reasonable then. He's saying any reasonable person would just know that you're counting on Ripple to do stuff, right? You're going to make the XRP worth more. Well, then that means that most first-time XRP purchasers are not reasonable, based on what the judge said here. They're not reasonable. Are you kidding me? This is so stupid. Oh my God, I hate this. This is so dumb. So here's what Attorney Hogan had to say. What the Terra judge doesn't know is that numerous XRP purchasers submitted unopposed affidavits that they didn't even know who or what Ripple was when they bought. That's why evidence matters. And there's no evidence in this case yet. And so look, I recognize that the judge has made the statement that he made outside of actual evidence. I get that. But the fact that that's his starting point and it's not in line with legal precedent is very alarming. Now, again, like I said at the outset, the good news is it's not going to impact the decision in the SEC v. Ripple case. Judge Torres is the one that got to decide that. We're golden. We're fine. But still, it's just like, it's offensive on its face to have this argument. Because you know what? I hold about 30 different cryptocurrencies. If people thought like this judge, which would be to think incorrectly, that could screw up the rest, decrease my net worth if the people like that were in power got their way. They would substantially, materially, financially harm me and everybody out there listening that's in crypto. Here's what Attorney Deaton had to say. I'm getting a lot of questions about the Terra Luna judge's rejection/distinction from the Torres decision. I'm traveling and haven't read the ruling. Earlier, I said a judge from the same district might be hard-pressed to openly disagree with Judge Torres. This judge apparently wasn't so hard-pressed. This is the very nature of litigation. I'll comment more after I've read the decision, but know this. Judge Torres was applying the Howey factors to indisputable facts at summary judgment. The judge in Terra Luna was ruling on a motion to dismiss. In Ripple, the SEC's expert witnesses' opinion on retail investors was struck, in large part due to our efforts, and the SEC had no evidence that retail investors were relying on Ripple. We submitted thousands of affidavits from XRP holders who acquired XRP with no knowledge of Ripple, as well as acquiring XRP for non-investment purposes. My confidence in the Torres ruling hasn't changed one bit from this judge's ruling. Welcome to litigation, people. Yep, spot on. So I'm looking forward to seeing the rest of what Attorney Deaton has to say, and I'm sure I'll cover it in a future video once he puts that out there. I'm assuming that there will be a Twitter thread on that. Well, now it's known as X, so I'm expecting it's probably what he's going to do. So as soon as we know, I'll be happy to add additional perspective, and everybody else is opining on this anyway, so there's going to be a lot more to say about this. And but again, the degree to which this would impact us as XRP holders, as far as my understanding at this point, is zero. But that's some crazy nonsense that happened. Isn't that absurd? Can you believe a judge? That's the starting point. The asset itself is the security, because that's what you must believe to argue what this judge argued. It's just absurd on its face. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.